All right, good afternoon. We're going to commence this meeting of the Advisory Council on Workers' Compensation for the state of Tennessee in Legislative Plaza, Room 16, Monday, March 20, 2017, at approximately 1:30 p.m. I'm David Lillard, Tennessee State Treasurer, and I welcome you to the meeting as Chair of the Council. The first item of business is to establish the roll call. Mr. Administrator Larry Scroggs, will you call the roll, please?
Yes, sir, Mr. Chairman. Chairman Lillard.
Here.
Mr. Dove. Mr. Fox.
Here.
Mr. Garrett. Mr. Hunt.
Here.
Mr. Pitts.
Here.
Mr. Schaefer.
Here.
Mr. Burleson. Mr. Denton. Ms. Fletchall. Dr. Graves. Mr. Harris. Ms. Lawyer. Mr. Mayo. Dr. Merle. Mr. Ramos, Ms. Smith, and the ex officio members, Senator Johnson, Representative Eldridge, Commissioner McPeak, Administrator Abby Hudgens, and our designees, gentlemen, Mr. Shinnick and Mr. Haley. You have a physical quorum.
All right. Thank you. All right, Mr. Scroggs, did you have a couple of administrative things first before we proceed with the agenda?
Yes, Mr. Chairman and members, I just wanted to point out that the loose sheet of paper that you saw on the top of your stack was an amendment, proposed amendment that's in the works on Dr. Briggs' Senate Bill 297. It appears that that bill will be rolled today to our next meeting. But that is it's a work, that's the first phase of work in progress on that. Just wanted to let everybody know that what that was. There is a proposed draft of that amendment that's in your packet, but this one with a barcode is the correct one.
Okay, so House Bill 666, Senate Bill 0297 by Matthew Hill, Representative Hill, and Senator Briggs, without objection, would be rolled to the next calendar. All right. Also today I want to announce that in a while I will have to leave to go be a member of the Council on Pensions and Insurance, and as we did at the last meeting, Christy Allen, Assistant Treasurer, will take over and preside at that time if we're still ongoing in our meeting at that point in time. Next item is item number 3 on the agenda, which is approval of the minutes of the Advisory Council's previous meeting on February 27, 2017. Any comments about the minutes? Is there a motion for approval of the minutes? We have a motion by Mr. Dove. Is there a second? Second by Mr. Fox. Any further discussion? Seeing none, would you call the roll? Mr. Scroggs on the motion.
Mr. Dove.
Aye.
Mr. Fox. Mr. Hunt. Aye. Mr. Pitts.
Aye.
Mr. Schaefer.
Aye.
And I don't believe Mr. Garrett was on the phone, but Chairman Lillard.
Aye. All right, so the ayes have it, and the minutes from February 27, 2017 are approved. Under item number 4, new business, is consideration and recommendations on proposed legislation affecting the workers' compensation system as introduced in the first session of the 110th General Assembly. First item on the agenda is House Bill 0157, Senate Bill 0177 by Chairman Eldridge and in the House, and Chairman Overby in the Senate. Let's see, do we have... Chairman Eldridge is here today to present on the bill.
Thank you, Mr. Chairman and Treasurer Lillard. And committee members, this bill is nothing more than a caption bill. Senator Overby wanted to file that as a kind of a backup, but I don't see it going anywhere, and it's going to be very well protected.
Okay. So we just dropped that from the calendar, I guess, at this point?
I'll drop it from,
okay.
Yes, sir.
Or without objection, that bill's dropped from the calendar and no longer shown as pending. All right, the next item, thank you, Chairman Eldridge. Next item is House Bill 0325 and Senate Bill 1214 by Representative Hawk in the House and Leader Norris in the Senate. Is anyone here on that bill today? Yes, Chairman Eldridge.
Thank you, Mr. Chairman. That bill is a administration bill on workers' comp, and I'm actually carrying it
okay.
on the House side. And we have Mr. Troy Haley here who can discuss it.
All right, Mr. Haley's recognized on the bill.
Is it okay if I sit here, or do you want me to go
That's
down in
fine.
front? Okay.
That's good.
House Bill 325 is the Bureau of Workers' Compensation's administration bill, and I went over this briefly at the last advisory council meeting, but I'll do another quick rundown. What the Bureau's goals are in this piece of legislation is fourfold. Basically, we'd like to eliminate some unnecessary form filing with the Bureau that serve no constructive purpose and increase our personnel costs. Second, we'd like to reduce the number of employees out there who are misclassified or don't have workers' compensation coverage. Third, the Workers' Compensation Appeals Board, we'd like to provide for an oral argument and to extend from 7 days to 20 days the time period for the Appeals Board to issue its determination. It's still the shortest in the country at 20 days. And last, we'd like to provide an educational benefit for injured employees who were not able to return to their pre-injury job. One of the most frequent criticisms of the 2013 Reform Act is that it reduced the benefits to employees who could not return to work. Most states have a vocational recovery assistance program in its workers' compensation system. We do not in Tennessee, and we would like to establish that here. The amendment, which makes the bill, drafting code 4593, accomplishes the following. The Bureau will continue to provide coverage forms as described in sections 2, 3, and 4 of the bill, but we will not be the record keeper of those coverage forms. Also, regarding the Vocational Recovery Assistance Program in sections 5 and 6, that will be limited as follows: a 3-year sunset following a 1-year implementation period. Also, the total assistance will be limited to a maximum of $20,000 for any worker. Aggregate disbursements by the administrator in any calendar year will be limited as a whole to $500,000 in the aggregate. Also, electronic proof of workers' compensation insurance coverage will be sufficient and will be encouraged by insurance carriers. The penalty for failure to provide proof of coverage at the place of employment or the job site will be limited to $500 for a first offense. And there were some minor housekeeping clerical edits as well. And I'd be happy to answer any questions if there are any. Thank you.
All right. Any questions of Mr. Haley in regard to the bill? All right. Seeing no questions or discussion on the bill, is there a motion with respect to the bill? I'll ask too, does anyone in the audience wish to be heard on the bill? All right, seeing none, is there a motion on the bill?
I move that the bill be passed.
All right, with a favorable recommendation, I assume, Mr. Fox? With a favorable, so Mr. Fox moves the bill's approval with a favorable recommendation. Is there a second for his motion? We have a second by Mr. Dove. Is there further discussion on the motion? Seeing none, Mr. Administrator, would you call the roll on the motion?
On the motion, Mr. Dove? Mr. Fox? Mr. Hunt? Mr. Pitts? Mr. Schaefer?
All right. Having received a unanimous vote, the bill is recommended for passage with a favorable recommendation. All right, the next item is House Bill 0666, Senate Bill 0297, which we rolled earlier, and then the one following that is the last one on today's legislative agenda, House Bill 0939, Senate Bill 0261 by Representative Carter in the House, Senator Johnson in the Senate. Is there anyone here to speak on this bill? Yes, ma'am. Come on forward and just turn on your microphone and identify yourself for the record, please.
Good afternoon, members. My name is Michelle Consiglio-Young. I'm Assistant General Counsel and Legislative Liaison with the Administrative Office of the Courts, and I had spoken with you all the last time on Senate Bill 261, House Bill 939. Representative Carter has had some issues with his mother being sick, and so I believe he was not going to be able to make this meeting. And then Senator Johnson also had informed me that he was not going to be here, but I will be happy to answer your questions and follow up on our conversation from the last meeting, which last time it was deferred because there were concerns with taking out the automatic right of appeal to the Supreme Court out of the appeals process for workers' compensation cases. And I did go over that with the Supreme Court, shared the concerns, and they have respectfully denied to change the bill at all. So they do want to move forward with the bill as is, keeping the discretionary appeal as a change in the bill and in the process. And the reasoning, for that is because of the way that it had been changed from the 2013 amendments going to the administrative process, and to comport with that, and to also make it in line with other civil cases that are heard before the Supreme Court, making a discretionary appeal.
Okay, are there questions of the presenter in regard to her statements or other aspects of the bill? I see Representative Carter's come in. Representative, we were just hearing about the bill here from your representative, and whether you have anything to add. Any questions at this point about the bill? All right, seeing no questions, is there a motion with respect to the bill? Chair will ask again if there's a motion with respect to the bill.
I would just comment that
Pick up your mic there, would you, Mr. Fox? Mr. Fox is recognized.
I would have a hard time recommending the bill or voting in favor of it in light of the loss of appeal by right to injured workers. And that, to me, I mean, the rest of the bill, fine, but that, to me, is going to be a real roadblock.
Mr. Pitts is recognized.
In a similar fashion, I think that sort of represents the attitude of the business side, and that is we feel like we're giving up a right that was present under the old law, and just don't want to do that.
Okay, well, the council has several options here, one of which is to approve it with a recommendation for passage, to approve it with a negative recommendation, or to send it out with no recommendation. Chairman Eldridge is recognized.
Thank you, Mr. Chairman, and Representative Carter. By the way, I'm not a voting member on the committee, but it was talked about one section of this. Would it be amenable to amending any part of this bill to get part of it out?
Absolutely. My name is Mike Carter, and I'm a representative from District 29. The AOC brought me this, and my concern in carrying the bill was simply this. You make sure that group is in 100% approval, then I'll go forward, because this is an extremely technical bill. The average person on the street is not going to understand it, nor do I. I never had maybe 2 or 3 workers' comp cases in my practice. But this is an extremely technical bill. We're dealing with human rights here, and we're dealing with human health and good workers, and I'm very concerned about this. If you all can't agree, then I think we ought to hold the bill over for a year until we get a full agreement. I don't know what is pushing us to get it done. If the workers' comp, as we've made the change, I'm not really sure how effective it's being. I hear both sides, and so I'm not sure about that. But my concern is that if we're perceived as restricting workers' rights that we have now, that's going to be a very difficult thing to overcome. And if we are doing that, then just to be candid with each of you and respectfully, I need to know what problem we're correcting if we're doing that. That's to me, and I was a defense lawyer and a plaintiff's lawyer, but that's a pretty significant step. Now, perhaps the court's covered up with these appeals, and I understand that if there is, maybe we could do something else. So I'm here, and this may seem odd to you, but I felt like I was here to serve this group, that I didn't have time to understand it, figure it out, do what you experts do. We want to improve the law and make it better. If we can do that by carrying the bill, and you all agree with that, then I'm happy to do that. But I'm here to serve you in that regard. So I'm happy to make any amendment you want to make. I have no authorship pride in the bill. I just want to make some changes that will assist both sides in the bill to make it work better as it works each time.
Chairman Eldridge.
Thank you, Mr. Chairman. Mr. Fox, you brought up a good concern about one amendment. You'd be all right with the bill if that one part was amended out?
Yes, I would. And looking back on our discussion last meeting, that's what we came down to. And we said, look, we can support everything in this bill except both sides agree
Right.
that this appeal by right's important to both injured employees and employers and their insurance carriers. And neither side wants to give up that right of an appeal if they think they've had an adverse decision. And so I'm pretty well stuck on that. Other than that one provision, yes, the rest of the bill I would have no problem with.
Then I would defer back to the sponsor of the bill to see if he'd be amenable to doing that, to move the bill forward.
May I address?
Yes, Representative Carter, surely.
Thank you, Mr. Treasurer, Mr. Chairman. I guess in this situation, I'm sorry. I'm extremely concerned about that. On the other side, I was a judge at one time, so I try to look at both sides. I'm very concerned about the impact this has on the court. These appeals go directly to the Supreme Court. I assume that's a large number. Could we compromise in some way and provide an appeal, but provide it in a place other than our Supreme Court so that they're not just covered up with these issues? I mean, if we appealed to the Court of Appeals of the district in which the injury occurred, that just came out of my mouth and out of my head, so it doesn't clog up the Supreme Court. And I assume the Supreme Court has a large number of these.
Mr. Representative Carter and members, let me suggest this. As Representative Carter rightly said, this is a very technical bill that affects people's fundamental rights in many respects. And I think we're going to, in consultation with Mr. Scroggs, we're going to have at least one more meeting of this council, this legislative session. So I don't know whether we again need to say that we need to roll this bill to the next meeting with a desire to earnestly work on it, either to get it in some shape where the bill can be reported out, whether it's with this particular provision or some modified form thereof. And I'm sure all the parties involved are willing to work hard at that, and one way or the other. So I think it's difficult in a bill like this to do things on the fly here in front of the council is one of the issues I have as a lawyer with this as a suggestion. So, Mr. Pitts, do you wish to be recognized? Then we got Mr. Fox, okay? You need to go first?
I'll do age before beauty. Go ahead.
You may have won on both counts. To the sponsor, and I offer this only in trying to be sure that you have enough information to know, I guess, where the issue really is. The court is probably going to come back and tell you that's the way they have it in all their other appellate processes, and they are striving for consistency. On our side of the fence, or I guess the other argument is that this was a right granted in this state a number of years ago, and just because we have converted to an administrative system for the balance of our workers' comp, neither representatives of the employer community or the employee community are comfortable giving up this direct access to the Supreme Court. Then my concluding comment that I stand to be corrected, but it is our belief that the number of appeals directly to the Supreme Court are quite small. And if anything, the addition of the administrative system is probably going to reduce that. So we are sort of, or at least I am, and I think some others, are coming from a perspective that this is a very important right. We do not believe it has any numeric significance in the cases to the Supreme Court. And for that reason, that's why we're reluctant to move the bill. I would conclude by saying to you, if you come next time, since we are advisory, I would anticipate that there would be a motion of some sort. I cannot believe that as a council we would leave you hanging and let a bill fail in this committee. Not that it dies ultimately, but without some direction from us with respect to your legislation.
Mr. Fox, you recognize?
Just a brief point on something you brought up about it tying up the resources of the court. These appeals are typically heard by a special panel of the Supreme Court. Sometimes there's only one Supreme Court justice on that panel. They can bring in retired judges, appellate judges, trial judges that are retired and on standby, and making up that panel. It's usually just a panel of 3, so it's not really tying up the resources of all the justices that wants to hear workers' comp appeals. And in each section, I think typically that's the way it works. In Knoxville, where I practice, it's usually a 3-person panel. I don't know that that procedure's changed. It's been a while since I've had a case go up, but if that's a concern, I don't see that that's going to change anything.
Representative Carter, you recognized.
Thank you, Mr. Fox. I don't know what I don't know, and I know so little about this because I'll just be honest with you. I understood you all were the where the bill was going to be approved and be brought, and so I was relying on you to do the right thing. If we've got a disagreement within the panel, not to say that I'm the final arbiter, but certainly I want to become more knowledgeable about this. I want to know what I know, not surmise. I've spoken to no one at AOC nor the court about their reasoning, and don't know that I will. But I am concerned that I know so little about the bill to discuss with you, to advocate it, because I literally thought this was a bill that was unanimously approved by this group and was more of a uniform acts kind of passage, just a perfunctory matter. So it's pretty clear to me that I need to know more about this and find out more what's going on, and then respectfully, I'll do what I think is best, or I'll give it up to someone that knows more than me. But I certainly respect this panel. I assume you're all volunteers and you're what makes the wheels grind, but I've got to go home and go to sleep with the bill that I supported. So I'm happy to hear from any of you. I do think I need to get far more educated on this before I move the bill. This bill can come up next year. It's a 2-year session, so I would much prefer to hold the bill than to make a mistake with it. But we can get together, and I would have no... I've been out of town a big part of last week with my mom, who's sick back in Chattanooga, and so my time is very limited this year, where normally it isn't. So if her condition maintains, I'll be happy to make myself available to any and all parties to do the right thing. But I've never had Supreme Court intervene in any bill I've got down here. They intervened on some of my cases back when I was a judge, but that's all right.
Representative Carter and members of the council, since the justices of our Supreme Court have asked that this bill be considered, I think that's something that needs to be dealt with along the way also and considered. Absolutely. And taken into account. And also we have members who have views on the bill that have been expressed here today. And I would ask, based on what's transpired here today, that we roll the bill to the next meeting of the council, which we'll have to get together here soon to do other things as well. And then hopefully in the meantime, we will work together to try to have the parties who have views on this bill arrive at some determination that will allow it to leave the council with some type of recommendation going forward.
Chairman Lillard,
Yes.
can I be recognized on one point?
Yes, sir. Mr. Ramos is recognized.
The one thing that would be helpful, I think Mr. Pitts is correct that but I don't know for sure, that the number of appeals now under the new law to the Supreme Court is very low. I don't know that for a fact, but that's what I believe is the case. I think it would be really helpful if we had that actual information when the bill comes up again as to the number of cases that have actually been appealed from the appellate level in the Bureau of Workers, from the appellate level to the Supreme Court. I think that would be a great piece of information to have. Thanks.
I can give you that information. You are right. I mean, it was low. It was only 8 last year, but that was some of the reasoning of the court for saying that it will probably go down even more with the new changes that have been put in effect from 2014. And so it's not really a workload issue. It was more of a consistency issue with other types of civil cases, that it's a trying to have it consistent with other types of cases. It's not a workload issue. And I don't want anyone to be misled or think that it was the issue, because it's not for the court.
Okay. Is there objection to rolling this bill to the next calendar? Seeing no objection, it's ordered without objection. All right. Thank you, Representative Carter, and thank you, ma'am, for
Thank you
appearing
for
today.
allowing me. I'm sorry I was upstairs and
all
in
right.
another meeting and ran down, so I apologize for being late.
Appreciate you coming today.
And thank everyone for your time that you spend here. I'm normally sitting up there asking questions, and so I appreciate the time. And there's a person behind every one of these cases, and there's an employer behind every one. And we want the right thing done in every instance. And if I can help with that, and my co-sponsor, my good friend from Jackson, if we can do that, we want to be a part of that. If we're going to fool around and mess something up, neither one of us want to be a part of it. I'm speaking for you there, Jimmy.
All right.
Thank you so much.
Thank you very much. All right, next item on our agenda is number 4B, which is presentation of a draft revision of medical fee schedule by Abby Hudgens, Administrator of the Bureau of Workers' Compensation. So, welcome, Ms. Hudgens, a member of the council. Chair will point out, as Ms. Hudgens is preparing there, that in the front of her slide presentation, she'll point out there's a slide that says that the Administrator of the Workers' Comp System, in consultation with the Advisory Council, is authorized to establish by rule a comprehensive medical fee schedule. The question that will be before us after this presentation is whether this council has any comment on the presentation or on the revised fee schedule that's being presented.
Thank you, Chairman Lillard. First of all, I handed out an enormous number of pages of rules, and I'm not going to go over each of those pages, so I hope that is something of a relief. But I did want to go over basically what we did in these fee schedule changes. As Chairman Lillard mentioned, our technical person, there we go. I wanted to point out, because we've not brought the fee schedule to the committee, to the council for a while, the role of the advisory council, and that comes from statute. And as Treasurer Lillard mentioned, that the administrator, in consultation with the advisory council, is authorized to establish by rule the fee schedule. We've had a fee schedule for many years, which means that from time to time it needs to be revised. And then the second provision is that the administrator, in consultation with the advisory council, shall review the fee schedules on an annual basis. Now, it has been more than a year, so I wanted to just touch base and tell you why it has been more than a year. For the last 3 years, the Bureau has been reviewing the fee schedule. This was in consultation with the newly formed Medical Advisory Committee and Medical Payment Committee subsequent to the reforms. What we were trying to do was to make the fee schedule as effective as possible. There were some complexities, there were some failure to provide coverage for certain services, and those required an awful lot of conversation and debate. In particular, I'll be talking about hospital charges, and that involved a lot of study that took quite a long time. The next slide just tells you, it's for your reference, to tell you what the fee schedule is supposed to be, that it's comprehensive in scope. It addresses physician fees, surgeons, hospitals, drugs, ancillary services. But the goal is to assure the delivery of quality medical care and access by injured workers while controlling system cost. And so here's where the major changes that we've made are. And this was the one that involved more conversation than anything else. It involved multiple formulas for how to do this. We worked with NCCI. I think we had to go through 3 iterations of proposals to come up with the changes that were needed in a revenue neutral way. So the biggest change is a change to the payments in hospitals, and particularly level 1 trauma. Level 1 trauma admissions seem to involve disputes between the payor and the medical providers that had to be resolved or discussed by the Medical Payment Committee. So we were looking for a way that was more in keeping with how health plans provide charges, and also eliminated these sources of dispute. So these are the changes that were made. The lab and radiology charges are no longer carved out of the per diem. They're part of the per diem, which is consistent with health plans. The per diems were increased, but the out-of-pocket, the stop loss was decreased. And that's what enabled us to make the changes in a revenue neutral way. And this was agreed to by all the various stakeholders that participated in those conversations. Other changes were that the billing codes were added for payment to physicians for causation opinion. Before the reform, there was not a need for a causation opinion. After the reform, physicians did not have a code. Most of our codes were based on Medicare. Medicare obviously doesn't have a code for causation opinion, nor did they have a code for drug and alcohol counseling or for the extra time spent with a case manager. These are all expenses that are unique to workers' comp. So if we wanted a system that was fair and compensated physicians for what we wanted them to do, we had to have new billing codes. This is a small thing, but it just shows you how sometimes things can get out of kilter. We were getting charges from physicians for record search when they never found anything. So we are eliminating the ability to bill for a record search if no records are found. Another thing that would make the medical fee schedule easier to work with, less complex, eliminate disputes, would be to adopt more Medicare definitions so that people would have a basis for understanding what they should do in keeping with what they do in other plans. An additional change was that we added language to enable us to do e-billing. This is a little-known fact, a little-known part of the Reform Act of 2013. The 2013 reform said that we would implement e-billing after 2015. And we've delayed it because there were so many other things that were had a higher priority in the reform. But we're at the point, we're in the process of preparing the implementation guide for e-billing, and we needed to add some language to the fee schedule for that. One thing that we did, what we felt like would improve the system, was also that we remove the automatic mandate for utilization review for physical therapy and occupational therapy after 12 visits, and also for psychological treatments and retrospective review of emergency ambulance transport. These were all things that were studied and felt like were in the best interest of the system. Now, I also handed out a little 3-page handout that gives a summary, a little bit more in-depth summary for you to review. Basically, it goes over a lot of what we have, what I've already mentioned. One thing that wasn't mentioned was telehealth, and that is a new emerging area of healthcare medical services. We needed to add something for that in the fee schedule. Another area that was a problem area I just want to point out to you was sometimes there is a problem in the system with communication, and sometimes it leaves the medical provider not knowing for sure whether he can go forward with recommended treatment. So if you look on page 2 where it says pre-authorization, there is a new provision that says if a medical provider makes a written request for approval of treatment, he receives confirmation from the payer, insurance company, or self-insured employer that they have received that request 21 days in advance of when the treatment was supposed to take place. If that takes place and the payer never lets the medical provider know whether it's approved or disapproved 7 days in advance of the proposed treatment, then there is a presumption that that proposed treatment has been approved. This addresses a concern where sometimes treatment is delayed, it's denied by delay. We want the payers to actually respond one way or the other. And so the incentive is that they don't, it will be presumed to be approved. I don't want to take your time with going over each and every one of these unless there's one that you would like to have more information about. So I'd be happy to respond to questions that you might have.
Okay, are there questions of Ms. Hudgens or discussion on this matter? Mr. Dove's recognized.
So thank you, Abby, for putting this in front of us today. I do have a couple of questions. When these changes that you guys made, did you, when you were studying that, did you model the program after any other states? And I guess specifically this billing codes that are added for payment. Is that something you create, your group created, or is it something that you got from insurers or?
No, we spend a lot of time with the different stakeholder groups we work with, and this came from discussions on what was keeping the system from being as good as it could be. There have been multiple meetings where, for example, pain management specialists would say, I'm not compensated for the very thing you say is important to do, which is counseling these employees on what they need to do to appropriately handle their pain management. So it came from several years of hearing concerns and feeling like they were valid concerns.
So you heard these concerns by the provider, from the provider?
From the providers and also from people on our 2 medical directors who, from a professional perspective, were looking at the issue, and they saw the problem as well.
Okay. Thank you. The other is, I'm curious as to what data you used to remove the mandate for utilization review after 12 visits of PTOT.
Well, at this point, I will ask our medical director to come up and speak to us because he is the absolute expert on this,
Okay.
Dr. Robert Snyder.
Thank you.
Thank you, gentlemen and ladies. In response to the first question, for causation for alcohol and abuse counseling, Colorado already has those codes in place. So we did not just de novo take that on. There are other states that compensate for that. So the next question, would you? Oh,
Has to do with
It's the mandate of UR for PTOT.
well, the only thing that we did was we made it discretionary. It just took away the actual mandate for it. We made it discretionary, and that way, if the adjuster, and let me give you a perfect example. Shoulder surgery, the recommendations from the treatment guidelines are 24 visits, okay? We had the mandate that said that after 12 visits, you had to send it back through utilization review. And so by removing that mandate, by allowing the adjuster, the utilization review company, to say, well, the patient's had the surgery, then we don't have to review it until after those 24 visits. So it just allowed the insurance company and the utilization review companies to use their discretion in special cases where everyone knew that it was going to be over 12 visits.
If I could just interject a bit here, one of the things that motivated us was to take out unnecessary bureaucracy from the system. So this does not prevent a payer from asking for that pre-authorization. It just allows them to, the law says thou shalt, and it saves them time and money. It saves everyone time and money if it's really, there is an obvious need for more than 12 visits.
Dr. Graves is do you have that concludes your questions, Carrie? Did you have something else?
I was just going to make
Okay,
a comment.
go right on ahead.
I will say this: in my career, we've experienced that the more visits that are available out there, the longer it takes for an employee to recover. And we track that very closely, the experience we had. And when we started really reviewing utilization of PT after 12 visits and putting restrictions there, we saw an improvement in employees' health very rapidly. So I encourage you that the changes are good, but I encourage you going forth, if you track that, then we can look at it in another 18 months and see how well that's improved, if it's accomplished what you really intended to accomplish. Thank you.
Okay. Dr. Graves is recognized.
Would it be appropriate for clarification for those up here that to know that when you take the restrictions off of the 12 visits, that we still, as a group of physicians, are held to the ODG guidelines, and that by removing the restrictions that were placed by law in there doesn't mean that it's freewheeling now. Now we're held to the ODG guidelines and judged by that. Would that be an appropriate statement?
That's a good point.
Other questions or comments? Yes, sir, you're recognized.
Jason Denton and Dr. Snyder, I have to publicly, I guess, commend you on how accessible you've been as a medical director. You know, you and I have had several conversations and had several issues with utilization review. I was just wondering if there's any motivation to maybe make the same discretionary move that's been made on the physical therapy on MRIs and CT scans, because I see that more often than not in my practice, that the reason why the plaintiff or the injured worker is darkening my door is because they can't get simple diagnostic studies approved timely, and the excuse is always utilization review when I dive into it with the adjuster, and they're saying that it's mandatory, even though technically sometimes it's not. Could that be included as well with the discretionary moves on the physical therapy?
This comes into the purview of the insurance companies. Essentially, it's a contract, as you know, between the insurance company and the employer to provide those services. The insurance companies have their own policies concerning what does and does not go to utilization review. Okay, we try to regulate that in the sense that we try to say, well, what's in the best interest of the patient? When the adjuster says that it's mandated. It is not mandated by the state nor any of our rules. It is more the internal policies of the insurance companies concerning certain levels of treatment, certain cost implications. And so within our rules itself, there's no mandate, no state mandate, that MRIs and other diagnostic procedures have to go to utilization review.
Dan, sure. Mm-hmm.
But what is the dollar threshold that is mandated by state regulations? There is none.
There is none.
Okay, Mr. Dove, Ms. Fox, excuse me, I'm sorry.
We've been discussing a bill that Senator Briggs rolled that did address utilization review as far as what was mandatory and gave a dollar amount of $500. Of course, it still would remain discretionary. Is a dollar threshold something that the department would find acceptable as far as setting one for utilization review with a limit saying basically if it's a $500 threshold, anything below that does not have to go to UR, but it would be discretionary?
Let me address the original bill, which was $1,500, and we found that to be troublesome. I talked to some plaintiffs' attorneys and sort of asked what was behind it, and I was told that one of the concerns was they felt like too many UR appeals were denied. And so I asked Dr. Snyder to look at those numbers, and only 37% were denied. So I'm not really comfortable about the real need for eliminating part of the UR appeals, but I would say it's something we could discuss. I'm not sure the dollar amount is the right place to go. It might be certain procedures rather than a dollar amount, but it's something we would be happy to discuss between now and our next meeting.
And that would be in conjunction maybe with discussing pre-authorization at 21 days. It would seem to me it should be shorter. I mean, that's by the time you add this 7 on top of it, you're giving them a month.
Right.
And if you need the treatment,
right,
it's a ruptured disc in your back, and you've got to wait 30 days to get the MRI. Having just experienced that, I was fortunate. I didn't have to ask. I got the MRI within a week, and I had surgery within 10 days of the event.
As with almost...
And that helped me a lot.
Yeah. As is our policy, we are happy to discuss these things.
Okay. Let's make a note of that and discuss in the context of the 21 days versus a monetary amount. I'd like to have that discussion with the department and work with you on something that would be good for everybody. And
okay.
That would eliminate one issue in Dr. Briggs's bill that we could take off the table and maybe could narrow it down to 3 things instead of 4.
Okay. Mr. Hunt's recognized, and I'm going to ask Ms. Allen, Assistant Treasurer Christy Allen, to come forward and preside since I've got to go to the Council on Pensions here.
Abby, thank you for the cliff notes. It's very helpful. But I am curious on the bullet of the fact that changes will be revenue neutral. Just seeing the opportunity for doing a second eval for the chiropractor, provision for additional PT, OT, additional billing, alcohol counseling. Where are the savings that allows this to be revenue neutral?
Well, the revenue neutral, and I'll let Dr. Snyder, he worked with NCCI as we worked on the balance between per diems, when you look at the change in per diems and you look at the change in the stop-loss attachment, it's revenue neutral about the hospital charges, which is different from the extra charges you're talking about. I will only give you my personal opinion, and this goes back to Dr. Snyder and I may disagree a little bit about why we made some of these changes and whether it was because of Tennessee or other states. While Colorado may do it, my opinion really came from trying to discover what was best for patients in Tennessee. In particular, that counseling for patients who are in pain management. The more you study pain management, the more you hear anecdotes about pain management. It is clear that it is very difficult to get someone off of opioids. And they often don't want to do it, or they're afraid to do it because their pain is such, or they may not realize that opioids are part of their pain syndrome. It just became really clear to me, and that was just a personal opinion, that we needed to be providing that counseling from the pain management specialists to help. We need to compensate the doctors for their time. And the payoff is that you have a better outcome. You're more likely to have someone get off their meds. That's a long shot. I'm not going to pretend by saying we would provide for that counseling, someone's automatically going to get off. Someone who's been on opioids for a long time, it is a tough road. But we do have that potential. More importantly, we would have that potential with people who are early in their treatment with opioids. And this is one we want to have counseling when they start on opioids, to warn them about the dangers, to warn them about how difficult it is to get off. So that is sort of a leap of faith on my part that that counseling will help.
I have no disagreement with that, but the expediting the care to the patient, in other words, making sure that the best quality care is available to our injured workers, is why it's important, especially in these long-term claims, to try to make sure that they get the time they need. I'm sure you've all been to a doctor and you've waited an hour and you're out in 5 minutes and you're not happy. And so anything that we can do to make sure that that communication is important. I think that if you look at the causation, the question about causation, the quicker a decision is made concerning causation, the better the results. In other words, if the patient needs treatment and we can get that patient that treatment as quickly as we can, and anything that we can do to expedite that. And so we want to make sure that as quickly as possible a decision is made concerning causation, because going forward then, we know who's going to be taking care of that patient, and there won't be any argument about, well, who's going to pay this or who's going to pay that or what's going to be delayed. So that was another reason why we wanted to make sure that we moved these decision points as quickly as possible, get them expedited, get them going as quickly as possible.
Dr. Graves, you're recognized.
Again, I just want to emphasize that a lot of these that I see in here are part of the cog and the wheel that makes the new ODG guidelines work appropriately for the doctors and the insurers, and that it's not just unleashing aspects of the care that would be just off the cuff. All of them are designed to make the cog of the new ODG guidelines so that the physicians understand it and the insurance companies understand it and that. And if you start taking these out as individual pieces, you start messing up the cog of how this is supposed to work for the physicians and the employees to get the care they need. So I'd just like for everybody to keep that in mind when they see these on here, that it's part of making the machinery work effectively for physicians too, along with the patients.
Are there any further questions? For Mr. Pitts, you're recognized.
Maybe I couldn't think of anything else to bring up, and it probably has no relevancy. But you say you're providing new codes for services. Any idea how many codes we might be talking about?
These are not new codes. These are standard CPT codes in the standard book. What we did, though, is we authorized the insurers, actually authorized the physicians to charge for these services and for the insurers to pay for them. In the past, it's been discretionary. The codes themselves are not new. These are standard CPT, AMA codes. And what we wanted to do was extend that to the injured workers, that it wouldn't be automatically denied.
How many might we be talking about?
How many codes? 6.
Thank you. Abby, I realize that technically you've done it correctly on your revenue neutral comment under inpatient hospital charges, but I really think you ought to go ahead with that sentence and say for inpatient hospital charges. Because somebody going to read this and think it applies to everything, and it doesn't.
Members have any?
Is there a CPT code outside of workers' compensation for the causation opinion? That's a new code, isn't it? Unless I'm mistaken.
That's an extra. Actually, it's an extra report code. Okay, it's part of the workers' compensation. There's about 4 codes that are directed at workers' compensation utilization and reports. And the only thing we did was we took that one code and allowed it to be charged for the causation.
So it's
a
actually a CPT code?
standard. It's a standard. We did not make up or change any of the wording on those codes. They're all standard to CPT and are accepted by Medicare.
Do you have a price range on what that code's going to pay?
No, I don't. It will be the same as the Medicare code. It'll be paid the same as Medicare allowable.
Are there any further questions from members of the council? Seeing none, thank you for your presentation. I do actually have one question. What is the current posture of your rules?
Posture.
So have you filed notices of rulemaking hearing? Are you doing rulemaking hearings? Or?
We have prepared the rules, but we were not going to go to the filing until we had this meeting.
Okay, thank you. What's the will of the council? Mr. Pitts, you're recognized.
I'm jumping in the dark. May I start with a question? Does anybody on the panel have any heartburn about what you've heard? Pardon? Yes. Could you talk about it?
Mr. Fox,
we're going to be asked to make a recommendation.
Mr. Fox, you are recognized.
I think perhaps my biggest heartburn is with utilization review. I mean, that seems, I'm like Jason, I'm getting more and more calls and delay in treatment for utilization review or pre-authorization. And if we could address those in a more concrete fashion, then I would feel a lot better about it. That's why we've had a bill proposed through Senator Briggs that addressed at least a threshold for UR, and maybe pre-authorization and UR are 2 separate things, but there's got to be some way to assure prompt resolution of recommended treatment that we all could find acceptable. And that's my biggest issue with it.
Is there any further comment from the council? I believe I heard Dr. Merle, you're recognized. Dr. Merle, this is Christy Allen, subbing for Treasurer Lillard as chair right now. I've just talked to Mr. Scroggs. We will be having one more meeting. Looks like maybe tentatively April 3rd. You're recognized. Mr. Hunt?
Yes, Doctor, can you clarify the chiropractic service component that's allowing for a second eval following the initial treatment regimen?
If there's a significant change in the need for treatment. So if in the initial evaluation the chiropractor recommends a certain treatment regimen, and during the course of that regimen there is inadequate response and he changes the treatment regimen, then he would be able to charge a second eval code. I think Dr. Graves is going to chime in here.
You're recognized, Dr. Graves.
I'm a chiropractor, so if I may, according to the ODG guidelines, when a patient comes to a chiropractor, the ODG guidelines allow 6 visits. And then there has to be documented evidence that continued care is medically necessary by doing another evaluation based on function and that sort of thing. So the second exam is required to continue on with care, and one of the processes is if you're going to do the exam, if it's required to do the exam to continue on with care, if care is indeed warranted, you're going to have a point at which you're going to either end the care because it was not effective or document that it was effective to continue on. And so that's what the second exam is for.
Mr. Hunt, you're recognized.
So for purpose of clarification, you're saying the initial regimen, it could be 6 visits, which could then require second eval, which would then be 6 additional visits following that?
Yes, if the condition warranted, that's what's appropriate in the ODG guidelines as they have. It's a substantiation of continued care beyond that first initial 6 visits.
Any further comments from the members of the council? What is the will of the council? I believe there are a few options. One, you could recommend approval of the rules. The statute does call for the administrator to consult. It does not require the council's approval. You could...
We had a debate on that. Your boss had indicated he believed it required our agreement.
Then I stand corrected.
Not putting you on the spot.
At all. Then I stand corrected. I did, though, hear that there is another meeting coming up. Yes. There will be another meeting scheduled, and that there is concern from members of the council. So given that, what is the will of the council? Mr. Pitts, you're recognized.
Miss Abby, I need to hear something out of you. You had one suggestion, or do you all intend to look at that further, or do we put this off to the next meeting? Where are we?
I indicated to Mr. Fox that we'd be happy to look at his concerns. We'll consult internally. Be happy to look at that and do that by the April the 3rd meeting.
Would you be comfortable with delaying our recommendation until that meeting?
Yes, as I mentioned earlier, we've worked on this for 3 years. I don't think...
So you don't want to rush into it?
We want to get it right, yeah.
Thank you.
So without objection, it sounds like the council will take these rules up again at the next scheduled meeting of the council. All right. Is there any further business to come before the council today? Seeing none, the council is adjourned, subject to the call of the chair. Thank you all for being here.